What's good and what's Hannah Riders? My name is Vilimile Kumete. I am, of course, the creator, producer, and host of this brand new baby, the Nkantolo podcast. Now, for those of you who may not know or understand, Nkantolo is a Swati or Nguni word for court of law. If you're wondering what we'll be covering during season 1 of this pod, here you go. The apex court in Eswatini is the Supreme Court, which has powers to decide matters brought to it on appeal or review from lower courts and tribunals. Now, in season 1 of the Nkantolo podcast, we take a look at the most recent judgments delivered specifically in that court. We summarize and bring those judgments to you, our cherished viewers and listeners, so that you can get the latest developments in decided cases from Eswatini's highest court. After all, you and I are riders, traveling together to uncover the latest in our case law. So let's ride right now together on the wheels of justice, nice and steady, and find out what happened in the case of Zuba Ngihlale Investments versus Mtshali and others. Now, if you'd like to get a text version of this case, you can do so by visiting eswatinili.org. That is eswatinili.org, where it is freely and easily accessible. So this case was heard by the Acting Justice of Appeal N.J. Manzini. It was heard on the 16th of January 2023. He then delivered his judgment on the 26th of January 2023. The judgment records counsel for the appellants as Ms. L. Simelane and Mr. B. Kaba as counsel for the first 3 respondents. So we begin with a summary of the facts. An entity named Zuba Ngihlale Investments is a private company involved in sugarcane farming. This company is run by a certain Mr. S. Dlamini, and it engages in farming activities at Mapobeni, which is a piece of land situated within the Engevini Royal Crawl. Now, this land is classified as Swazi Nation land, and as thus, it falls under the jurisdiction of traditional authorities who derive their powers from Eswatini's customary law. Now, this piece of land, having been allocated to Mr. Dlamini's father, becomes the subject of a dispute between him and his siblings. So Mr. Dlamini claims that his siblings are interfering with the operation of the farm, and then he approaches the High Court to interdict or to stop them from continuing with their alleged interference. Now, evidence is then led by the company stating that it has gone to the extent of obtaining loans in order for its farming operations to continue, and thereby alleging that it has suffered a great deal of injury due to the conduct of Mr. Dlamini's siblings. Now, the siblings then file opposing papers against the High Court application, informing the court that the land dispute is pending before the traditional authorities. So on the one hand, Mr. Dlamini and his company claim a right to use and enjoy the land because they have paid what is called a konda fee to do so. On the other hand, Mr. Dlamini's siblings claim that their brother does not have any exclusive right to appropriate the land and use it for his exclusive benefit. And so in October 2022, the learned Judge Makakula of the High Court makes an order granting the application in favor of the company and Mr. Dlamini. But he does not give any written reasons for the decision. So Mr. Dlamini's siblings are clearly not pleased with the outcome, and then in a few days, they note an appeal in the Supreme Court. 2 months after the appeal is noted in the Supreme Court, Mr. Dlamini also approaches the Supreme Court asking for leave, or rather, asking for permission to execute or take steps based on the High Court order which was granted by Judge Makakula. Thereafter, Mr. Dlamini's siblings raise a preliminary objection. They state that the Supreme Court does not have jurisdiction to determine the application for leave to execute, and that the jurisdiction to determine the application lies solely with the High Court. So the company and Mr. Dlamini's views that the Supreme Court indeed does have jurisdiction to determine the application, and that this power is derived from the Constitution. Then the important legal questions are the following. 1. Does the noting of an appeal stay execution? In other words, can Mr. Dlamini execute the High Court order whilst the appeal is pending in the Supreme Court or not? 2. which court really has jurisdiction to hear and determine Mr. Dlamini's application for leave to execute? Now, Acting Justice of Appeal M.J. Manzini probed these questions and found the following. Let us then start with the first question. Does the noting of an appeal stay execution? The answer is yes. Noting an appeal in Eswatini's Supreme Court operates as an automatic stay of execution. The court based this finding on the 2020 case of Good Shepherd Mission Hospital versus Bembe, which was also decided in the Supreme Court. Now we turn to the second question about which court really has jurisdiction to determine Mr. Dlamini's application. Acting Justice of Appeal M.J. Manzini found that South African case law had already given a solid position which has been followed in Eswatini for many, many years. Now, the case law developed in Eswatini from this takes the clear position that the High Court in fact has jurisdiction. In this case, however, the Supreme Court found that there is absolutely no authority that states that the High Court retains exclusive jurisdiction. So Manzini AJA then made the interesting distinction between Eswatini and South Africa. South Africa's Superior Courts Act states at section 18 sub 1 that only the court which makes the order has jurisdiction. On the other hand, section 146 sub 3 of Eswatini's constitution is wide enough to confer power, authority, and jurisdiction on the Supreme Court to hear and determine applications for leave to execute orders, or judgments of the High Court if you like. This case is so important because in its judgment, the Supreme Court held that both courts, that is the High Court and the Supreme Court, enjoy concurrent jurisdiction to hear and determine applications for leave to execute. And so that was the end of the preliminary objection which was raised by Mr. Dlamini's siblings. The Supreme Court then dealt with the merits, having considered the facts, obviously. The court relied on a South African judgment in South Cape Corporation versus Engineering Management, which was handed down in 1977. This case essentially laid down the principle that a court seized with an application for leave to execute must exercise its discretion and do so while being just and equitable. AJA Manzini notes the counter-argument made by Mr. Dlamini's siblings regarding prejudice. So they argue that any prejudice suffered by Mr. Dlamini or his company is self-created. And what do they mean by this? The siblings say that the traditional authority, namely the Engevini Royal Kraal, has made it clear that their deceased father was the owner of the land, and this means that all his children should benefit from its use. Now, the court's order was then to refuse or dismiss Mr. Dlamini's application, and the reasoning for refusing Mr. Dlamini's application was based on the following factors. 1. The traditional authority had already determined that the land belonged to the family. In other words, it belonged to Mr. Dlamini and his siblings. 2. Granting leave to execute would then be undermining the decision of the traditional authority who has jurisdiction over the land. 3. Mr. Dlamini had failed to establish a clear right which entitles him to bring his application. 4. If leave to execute is granted, the siblings would have no say on how the family land is used, and they could be unable to participate in any profits from the farming operation until the appeal is finalized. And then lastly, in the absence of written reasons from the High Court, it cannot be determined whether Mr. Dlamini has prospects of success in the appeal. The appeal justice went further and commented that it was, and I quote, difficult to fathom how the learned judge a quo could have granted a final interdict without first having heard oral evidence regarding the clear dispute as to the right to use and enjoyment of the disputed land, which is under the jurisdiction of traditional authorities. And so, as I had mentioned earlier, Mr. Dlamini's application for leave to execute was dismissed, and the Supreme Court ordered him and his company to pay the costs of the litigation in the Supreme Court. Now, fellow riders, I would like to take the opportunity to thank you for tuning in for episode 1 of the Nkantolo podcast. Please do not leave this page without subscribing to our YouTube page. It is called Nkantolo Podcast. It's just that simple. It certainly helps us in a major way if you do subscribe. So give us a thumbs up if you found this episode to be particularly informative, and also hit the notification bell to see our future uploads. I would like to hear your views, obviously, on this case, so please be sure to give us your comments or your thoughts in the comments section. And until next time, salute.